Are you contemplating divorce? Hi, I'm Simon de Bernard and I'm a family attorney. If you're on the verge of divorce, your priority is ending your marriage and doing so with as little trauma as possible. You know that there are financial hurdles ahead, but these are probably not front of mind. It's an emotional time, and your future and the well-being of your children, if you have them, is your first priority. Now, I don't want to sound callous, but your finances should be high on the list of considerations. It's your attorney's job to look after your interests, but it helps if you have some financial literacy when it comes to the details of the divorce agreement. The decisions you make now can't be easily undone. Changing your mind in future will incur cost and will be very disruptive. It'll reopen old issues and arguments you thought were closed. So what do you need to know about finance and divorce? I've put together a glossary of terms for you, and I'll go through them over a series of talks. Some of them will be familiar because they're not unique to the divorce context, although they have particular relevance to divorce proceedings. Other terms are specific to divorce and may be new to you. In this talk, we'll look at the role of the matrimonial regime in your divorce settlement. If you don't have an antenuptial contract, your marriage is automatically in community of property. This means that all assets of both parties are joined into what is called a common estate, owned equally by both spouses. Everything you or your spouse earned, brought, inherited, or acquired in any way during the marriage becomes part of the common or joint estate, including money in either bank account. Assets in a marriage in community property are usually distributed equally between the spouses when the marriage is dissolved, although there can be some exceptions to that. If you sign an antenuptial contract or ANC, you are married out of community of property. An ANC sets out the rules and conditions that will govern the division of assets both during the marriage and on divorce. ANCs don't apply to marriages in community of property. Marriages out of community of property may be with or without the accrual. The regime that applies will have an impact on how your assets are divided on divorce. In marriage out of community property without accrual, each person retains ownership of the property they own prior to the marriage, as well as all property accumulated during the marriage. They also hold sole responsibility for any debts incurred before or during the marriage. Marriage out of community property with accrual is a bit more complex and only becomes significant on divorce. When that happens, the difference between the net increases in the respective estates during the marriage is divided equally between the two parties according to a standard calculation. Certain assets are excluded according to the terms of the Matrimonial Property Act. You can't change your matrimonial regime prior to divorce. It's possible to draw up what's called a post-nuptial contract, though. Couples sometimes do this when they are married in community of property and decide at a later date to change their regime. But this is normally the act of a mature, stable couple who negotiate issues as partners committed to the marriage. Both parties must agree, and the matter must be approved by the High Court, so it's likely a spouse will agree to this when the marriage is breaking down. You can't change your regime in anticipation of divorce, but it is important to understand it. If you have any questions about your matrimonial regime or you want to discuss any of these matters in confidence, give me a call on the number in the signature below.